Alex here with a high conflict child custody video on behavioral orders. So, I've often tried to cite this video and reference this video only to realize that I haven't actually made this video. And I think one of the reasons why I'm so convinced, or at least was convinced, that I'd created a video on this topic is because of the video gray areas. And in the video gray areas, I talk a lot about behavioral orders. And that is because typically the way that the courts and even attorneys try to solve the problem of gray areas is to close the gray area, which is typically done with a behavioral order. And so that is the context in which they often come up. They're seen as a solution to a problem. And in the video gray areas, I explain why they're not. They're not a solution to a problem. Um, you know, I'm going to go ahead and define them now, and maybe I'll talk a little bit about that. But for the most part, you're gonna want to take a look at the video gray areas if you've seen this video, because it's gonna be like you're missing a big chunk of the information. So first off, what is a behavioral order? Now, my understanding, and I'm mostly sure this is correct, is that there are a few things that a child custody court can do, a divorce court can do. Child custody court can award custody, which is, primary physical. Well, actually, there's two types of physical custody: primary physical and joint physical custody. And then they have legal, which they just have joint legal and sole legal custody. I've heard of some references to sole physical custody, but what I imagine that is, it's just another parent got TPR'd. Or maybe it's like a grandmother or something that has custody and they don't share it with anyone. Maybe that's what it is. In any event, we don't need to talk about that. Aside from awarding all of these custodial designations and doing pretty standard stuff like child support, everything else typically fits into the behavioral order category. And those are orders that the court enters that really don't have anything to do with custody or child support. They're just trying to tell you what to do. Some examples of a behavioral order could be like right of first refusal, how to communicate with each other, like maybe only through our family wizard or through email, how long a phone call can be for, who's supposed to take what toys and clothes over to what house, when do you give stuff back. All of these things are trying to control the behavior of the parents. And all of these things, in my opinion, if I'm right, are what behavioral orders are. It's just trying to control your behavior. It's not really altering the legal. It's not really altering the legal or physical custody situation. It's not altering the dollars and cents of the child support. And so you have, these extra things that the court does. And I'm not even sure where the authority comes from. Typically, there is some kind of reference to the child custody judge. The judge who's presiding over the case has pretty much anything in his or her power, when it comes to the best interest of the child, and maybe that's where they get that authority from. I haven't seen any statutes that discuss the term behavioral order. I haven't even really seen case law on it. Maybe there's some case law that references behavioral orders, but it just seems to be settled that if a judge is doing something for the best interest of the child, and the judge can do it. And so you've got all of these other oddball orders that come out of these custody cases that I honestly think just makes things worse, especially in a high conflict child custody case. In a low conflict case, maybe, there is some basis for some of this stuff. Like the right of first refusal is a really common thing in a low conflict case, which I don't even recommend people put into the court order. Some other common stuff, even in a medium or high conflict case, is like text only, email only, use our family wizard. These things are as reasonable as it gets. But when you start to go beyond that, it just turns into a game for a lot of these high conflict exes. It's just a game as to what can they get away with, how can they exploit the court's order. And then I'm kind of leading now into what I talk about in the video gray areas. And I really do think that the solution to many of these problems has nothing to do with behavioral orders at all. It has to do with find out which parent sees it as a game, who's exploiting the way that the language of the court order is written. Find out who that is and just deprive them of custody. Give it to the other parent. All behavioral orders do is open the doorway for contempt of court motions. And, even some of the more common ones, like right of first refusal, which is a very popular thing, which again, I recommend against. Please watch my video on the topic. Even stuff like that you would think is just plain and simple to understand, and the purpose of it is obvious. Even something like that ends up leading to a ton of contempt of court motions. Ask people in high conflict cases who are living through the nightmare of right of refusal and the filing of, rapid fire contempt motions over all these disputes. It's not much different for anything else. Like in my case, you have that my ex has to notify me within 14 days of an appointment, that she has to exchange the homework packet, that she has to give the clothing back. that we don't have to exchange as any clothing except for what's on his back. Like, these are such silly things to police a parent over. The court would be doing a better job to find out who the knucklehead is that's not doing this obvious parental stuff, and don't give them custody. Something is wrong with them. Parents who love their kids don't do these things. They don't. It's the parents who are seeing it all as a game, who are almost infantile in their view of the world and the relationship. The severely emotional immature parents and the personality disordered parents who do these things. And so, I mean, you're going to add, one behavioral order after the next, and you're going to find, one contempt after the next, and it's just never going to end. There's just going to be more and more behavioral orders, more and more contempt motions, and the situation just gets more litigious. So anyway, I kind of merged way too far into what I talk about in the video, gray areas, but I'm going to go ahead and wrap this video up now. I feel like I've defined behavioral orders. I don't know if they're used much in divorce actions at all. The divorce court's typically concerned with divorcing the parties, separating assets, separating debts, and that's it. I suppose there may be something in there like you can only talk about, to each other through email from now on, but that might be like the only thing that they can do. It's mainly a child custody thing. Anyway, if anyone here has any questions or comments, please post them down in the comments below, and definitely take a look at the video gray areas, because I elaborate a lot more on this sort of what I view to be a problem, what I view to be a shortcut by many judges in family court who don't want to make the tough decision to modify custody. They just want to get people out of the courtroom and tell them to do stuff, which is just an impossible situation. And all it does is it teaches the high conflict parent to exploit the fact that the judge only sees them once every 5 or 6 months. And so anyways, guys, I don't want to beat a dead horse here. I'm going to go ahead and wrap it up now. Again, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.